my pens and paper. Yes, Mr. Malloy.
As the court, please, my lord, best wishes for the new year.
Same to everybody.
My colleague and I, Dr. Sibanda, confirm appearances on behalf of the state.
Okay, yes. Yes.
As the court places now, I confirm my appearance on behalf of the standard.
Yes.
As the please of the court, my lord, I confirm my appearance on behalf of Mr. Mapisa. Thank you.
Yes.
I confirm my presence on behalf of accused number 5.
Okay.
As it is the court, my lord, and good morning, my lord, and happy
Morning.
new year.
Same. Thanks.
Thank you, my lord, and I confirm my appearance on behalf of accused number 1,
Okay.
Mr. Sibia, and accused number 3,
3.
Mr. Mnube.
Okay.
I've just been making arrangements for the arrival of Mr. Gwabini, who was still in the witness box, my lord.
Where is it?
I will arrange that he be
Yeah.
ushered into the box, my lord. Thank you.
My lord,
Yeah, well,
maybe before we proceed, may I take this opportunity to thank the court for allowing me indulgence. Last year, my lord, when I went to that court, I was under the impression that we're going to take 1 week, my lord, but then the matter proceeded for.
Okay.
Thank you, my lord.
no, fine. Yes, sir. Morning. Yeah. Let's commence.
As the court, please, my lord, when we adjourned on the last day of term, I think it was around the 5th of December 2025, the court made a ruling regarding the statement of Mr. Sifiso Gwabini Zungu. The effect of the ruling that was made by the court was that in light of the fact that allegations of assault have been made against Brigadier Geninda, Sergeant Mohola, Sergeant Mohane, Constable Mapumulo, Constable Butelezi,
Yeah.
and furthermore that anyone against whom the allegations of assault have been made should have the opportunity to come and testify and comment on those allegations of assault. The court refers to its inquisitorial duty in terms of section 186, and the court then ordered that those witnesses against whom the allegations of assault were made by Mr. Absalom Zungu and Mr. Sifiso Gwabini Zungu should be subpoenaed so that they can come and testify in court. And the court further mentioned that since these allegations arose during the defense case, that the court will then exercise its powers in terms of section 186. We did present an argument, my lord, and indicated that in light of the decision in Makala's case,
Yeah.
that we think that the appropriate procedure will be for a trial within a trial. And we still of the same view. However, we are in the hands of the court in light of the ruling that has been made by the court. The witnesses have been subpoenaed and they are present here in court. Sergeant Mukhani, Sergeant Mohola, Constable Mapumlo, Constable Butelezi, Brigadier Gininda is also available.
Yeah, fine. Is that it?
Yes.
No, just one thing. I just want to check with you guys. Because you are saying we should have a trial within a trial. I even read some newspaper reports about so-called C lawyers saying they're surprised why we don't have a trial within a trial. When do you have a trial within a trial? Anybody can answer that.
Well, this issue has been debated at length. A trial within a trial
Yes.
is held to determine the admissibility of a statement by an accused which has been disputed.
Right. This way there. Which statement is being disputed?
Yes.
Is a statement disputed here in this matter?
Well, my lord, the evidence of Mr. Sifiso Gwabini is on record.
Yeah, you're fine.
Yes, he.
What is it disputing?
Yeah.
That's what I think, even myself, misdirected myself for the last time. What is being disputed?
Well, the court will recall that
Yeah.
we presented an argument, and
Yeah, section 190, fine.
yes,
I heard that.
and we don't really want to rehash the
No, you don't have to. I mean, I listened to all the arguments.
the argument. But
Let me tell you the biggest problem in this case, evidential-wise. That's why you were not able to cross-examine,
yes,
because in this case, we have this odd situation where your own state witness, whom you consulted, made a statement, right?
yes, indeed, my lord.
Right. And subsequently, you don't use him, fine, for whatever reason. You don't use him, okay? Then he comes in and gives evidence for the defense. But he does that after you have closed the state case. Are you with me?
Yes, indeed, my lord.
In other words, whatever he says in the box, and I don't want to advise anybody, whatever he says in the box after you have closed the case, if that evidence was not heard by a person who interacted with him, do you think that is fair? He says, I was assaulted by,
Yes.
let's mention Ratha. I was assaulted by Ratha. He kicked me like a 5-ton drum full of water. And subsequently, a statement was coerced out of me. And after this statement was coerced out of me, obviously it was coerced in the sense that I did not freely and voluntarily make that statement to get out of my impasse, my problems with the writers of the statement. I said to them, they must do this. Whatever accused number 1 has said in his statement, lift that,
Yes,
and put it into a document. I don't want to say a statement. Put it into a document and I will sign to signify, apparently according to him, to signify that this is not my statement. Am I correct?
yes, indeed.
you
That
with
is the evidence of Mr.
Now, this is the
Gwabini's-
problem. At what stage will that evidence be contested? At what stage?
Case.
And when you look at 186, it says this court must exercise fairness for everybody. For everybody. Here is a person who alleges or testifies about an exigency of a person who Maybe you guys have forgotten. A person who alleges in the form of Gwabini, not Ogininda, having taken a statement from a particular witness. Is that not the fact?
Yes, that is a position.
Right. And here we are we're arguing about whether there's a statement or not, when we all know that there was a statement taken by a person called Gwabini. I think in all fairness, because the lawfulness of these statements must also be tested. That's why I decided, okay, let's call everybody who had an interaction with this witness concerning his evidence. Because it is not about a statement in actual fact. It is about his evidence. Statement, it's about his evidence. I know you quoted Governor, theory, blah, 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 blah. We are concerned with evidence, not a statement. Because constitutionally, Section 35(3) of the Constitution says that either a witness or an accused person has a right to confront evidence. Am I quoting it correctly?
Yes, that is what the section says.
Yeah. That's what motivates me to not to deliver a judgment, but to wait for all the persons who were implicated. Otherwise, I don't know what they're going to say. Somebody may come here, I never have interacted with this person. Fine, no problem. Anyone for comments?
Yeah, if we can perhaps have the first bite. Well, the court will recall that the state wanted to cross-examine Mr.
Yeah.
Gwabini on his statement.
That's it.
So the issue at that stage was whether the state has proven the statement.
Yeah, fine.
And the defense then objected.
Was the statement used in this court? You guys forget Art versus Hepworth. If I recall, Mr. Mnisi never produced the statement allegedly, which
Yes.
was signed, if at all, with an S. Was it
Yes.
produced?
Yes, no, he was not led on.
No, I say, was it produced?
No.
It was not.
No, it wasn't. As I say, he was not led on the statement, so it
His
was.
evidence is, I signed a statement, S.
Yes.
That's what he says. Is that not the evidence?
Yes, that's indeed. It says he was told what accused number one said, and he then said he makes what accused number one said should be transferred to his statement, and he then signed by making that S.
And now that is his evidence.
Yes.
Now, this court can never ever stop the state from cross-examining on the utterances of a witness. I don't have that authority. I don't have it. A witness says, I signed a document or a piece of paper. I want to see it. If it's not there, then say, it is lost, like somebody said the other time. Okay. Any comments, Mr. Mnisi? We'll come to Mr.
Okay.
Any comments?
As it please the court, my lord. My lord, I think to some extent I would want to concur with what the court is saying. In that, when the state was about to cross-examine Mr. Gwabini on the content of the statement, then as a defense we raised an objection and said the state cannot simply decide to cross-examine without laying a foundation of the document on which the state says they want to cross-examine him on. That's where the issue then started, my lord. The state then made all those applications, which ultimately brought us thus far. But second to that, my lord, is the following. Remember, Mr. Gwabini in his testimony said, I had consulted with the state on a number of occasions. And when they wanted to test if I'm a suitable person to come and testify for the state, on those number of occasions, Mr. Gwabini has been told not to come to court. That is his testimony. Now, what was open to the state, my lord, at that moment, and I want to be very sincere with the state, what was open to the state, or an option that was available to the state at that moment, was to say, Mr. Gwabini, it's good. I have consulted with you, and on the basis of our consultation, I realized that you are reneging from what you allegedly said in the statement. But nonetheless, there's a remedy in terms of the Criminal Procedure Act. I'm just not so sure about the proper provision, but that I'll call you into the box and I'll make a proper application to the court to have you declared as a hostile witness. And then under those circumstances, my lord, then the state would have had the opportunity to cross-examine Mr. Gwabini on the content of his statement.
Yeah, it's fine. But one
Thank you,
aspect,
But-
I hear you, but
Yes.
one aspect you're missing is he's not a hostile witness.
Excuse me, my lord.
He is not a hostile witness.
Yes, that's
That's it.
yes,
He's not testifying on behalf of the state.
yes. That is the reason, my lord, that I'm saying that the state missed that opportunity.
Well, it was never there anyway.
Yes. And then they made Mr. Gwabini available to the defense.
That's another story.
Yes. Then we consulted with Mr. Gwabini. He gave us what he gave us.
Yeah, fine.
Then we said, Mr. Gwabini, come and explain what happened in the circumstance. Come and explain to the court what is it that you know around this incident that we are at court with. Then he came and provided his testimony, my lord. Now,
Fine, I hear that.
yes, in the cause of him now being called as a defense witness, the states come and say, no, but we want to cross-examine you on the content of that statement that we had interviewed you or that we had a consultation with you about before we made you available to the defense. Then we say, okay, no, it's fine. There's no problem. State can, in all means, is not wrong in saying that it wants to cross-examine him on the basis of that statement, but they needed to lay the foundation for cross-examining him on the basis of the statement that he said. And that is just to prove the statement, my lord.
Okay.
And that is our bone of contention.
Right,
Thank
Mr. Ramasipiri?
As the court pleases, my lord, without belaboring this point, we've made our arguments, and I concur with what Mr. Munisi says, my lord. And in opposition to what my learned colleague says, that Makala applies, therefore a trial within a trial should be held. We've made our arguments that Makala and the circumstances
it's not-
in that
it's not
were different,
applicable.
my lord. It's not applicable, as the court pleases.
Mr. Malu?
My lord, I have one problem. I don't have a problem with the court invoking the provisions of Section 186 of the CPA. But the problem that I'm having, my lord, is that can this court call these witnesses at the stage when the witness is under cross-examination? Because the court was of the view that
Yeah, you're right.
the witnesses can be caught at any stage.
Yeah,
but you are having
right.
a situation where the witness is under cross-examination
Yeah,
by
you're
the
right.
state. Can
Yeah,
then
you're right.
can then those witnesses come at the stage when this witness is under cross-examination? That is what.
No, you're right. I've got to make a ruling first. That's why I wanted to hear you. That's why I said I actually misdirected myself when I thought it is about a statement. It is not about a statement. It is about the evidence.
The evidence, yes.
I mean, the evidence led in this court, not a statement.
True.
The witness himself says, it took me to Primrose Police Station, 3 o'clock, 5 o'clock. I was taken out, taken to a gravesite from 12 o'clock to 6 a.m. in the morning, beaten up at that place we had the inspection in Loco.
Yes.
And thereafter, I was taken to the prosecution room. And thereafter, I was interviewed. But in between, he says he was being beaten up. I don't know which court is going to list. Just listen to evidence where a witness says I was beaten up. He was even beaten up by so-and-so, by so-and-so, by so-and-so, by so-and-so. And eventually, he makes a statement, according to him, which he says it is not a statement. But he signed a document. Now, I'm saying for fairness, all the persons who were involved in this, because if he had said this just after the cross-examination of Kininda, we wouldn't be having this problem. The state closed this case. I can tell you, Mr. Baloi, what I could have done. I could have made an application to reopen the state's case. Are you with me?
Yes, indeed.
Do you agree with it? Yeah, so that I can call whoever the witness says did A, B, C, D, E, F, G. But if you haven't done it, doesn't mean you can't do it, because this is not a court of technicalities. This court is about justice. Justice.
Yes, well, the fact of the matter is the witness is still
it's
under
valid.
cross-examination. So after the cross-examination, the state will have that option
Yeah, fine, okay.
to consider.
Oh, are you still saying?
Yes, so I was having those concerns, man.
Yeah, no,
so I
fine,
don't
I
know
hear
how
you.
the court is
I hear
going to,
you. Yeah.
going to allow the state to continue with cross-examination,
Yeah.
because he has to lay the basis or the foundation that we are going back to the same issues that we were faced with last year.
Listen to what the evidence says. The evidence says, that's why I say it's not about a statement. It's about the evidence. The witness says, I was manhandled, threatened, etc. in the office there, and I was being told that I'm involved in the murder of Senzo, and I denied it. I said, I don't know anything about football. I don't know anything about the goalkeeper, until I got so tired. I said, let me do what they want me to do. Just take whatever you say accused number one says about me and put it in a document, and I will sign that document. You see, that's the evidence. It's not about a statement. It's about the evidence. Because the statement is uttered by mouth. That's the evidence which it says. Even if, assuming the statement was lost, was burned down, like in South Africa, we burn buildings, even parliament. Assuming it was burned down, are you saying the court is going to ignore the evidence that there was evidence to the effect that I said, take this evidence which is said about me by accused number one, put it in another document, and I'll sign it. Even if the document is not there, are you saying that evidence just vanishes? Okay,
Thank you.
Miss.
Thank you, my lord. My lord, I'm going to make just two submissions. That the court at this stage is referring to the evidence that the witness has testified about,
quite.
that is on record.
Yeah.
And the state, my lord, is allowed to cross-examine on the evidence
Yes.
that has been tendered
Yes.
by the witness before this court. But now the issue in dispute now, my lord, it's now when the state wants to cross-examine on the content of a statement.
Was the content of the statement not publicized in court? Take what accused number one has written about me in his statement
Yes.
and put it into my statement or a document which I will sign, and I signed it in S.
Yes.
So in other words, are you with me?
Yes, I'm with
Yeah,
you, my lord.
so
I'm
there's
with you.
evidence.
Yes. So, my lord, the issue that arose, it was when the state was supposed to prove the statement from the witness. Because the state now wants to get into the statement of the witness who is testifying. The procedure, my lord, is that the state has to prove the statement. That is where the problem arose. my
Okay,
lord.
fine.
Yes, that's where the problem arose. To say, if the statement has not
So
been...
you're putting an onus on the state. Are you aware of that?
my,
You're putting an onus on the state.
my lord, let me just finish this sentence. To say, until the state is able to prove the statement, which is the procedure, then the state will be allowed...
Which statement are you talking of? Because there are three statements here.
My lord, the statement that the witness wants to cross-examine the witness on.
Which one? Which statement is it?
It's a 204 statement.
Is that so?
It's a 204 statement.
Because I heard Mr. Rama
But my lord,
say that the 204 no longer exists.
my lord, also I cannot limit the state as to. I cannot limit the state as to which statement. My submission
fine,
is
fine,
that
okay.
whichever statement that the state intends to cross-examine on, that statement has to be proved first, so that the state can be able to cross-examine
Okay, fine.
on the content of that statement.
All right.
Now, my lord, that the witness is still on the witness box. I understand there has been a ruling that the witnesses who are the police officers that were involved in the taking of the statement have been summoned.
Yeah.
My submission, my lord, is that whilst the witness is on the witness box, he has to finish
Yeah, fine.
his cross-examination.
Right, yeah.
Once he is finished with cross-examination, the state has to finish a cross-examination of this witness. Then after the witness has finished, the court can direct on the ruling as to how it should be conducted, my lord. We all understand the provisions of Section 186 that the court can call the witnesses at any stage. But my lord, my respectful submission is that no witness can, this witness cannot, we cannot suspend his cross-examination at this stage.
No, I'm
He
not
has-
sustaining it.
He has to finish the cross-examination, and then the witnesses that the court has indicated that they must be called, then they will be allowed to testify, my
Okay,
lord.
fine.
Yes, my lord. Those
All
are
right, this is my ruling. Like I told you, I misdirected myself. There is no law which debars the state from cross-examining Mr. Gwabini on his statement, on the statement which he says he signed. There is no law. Check the law for 3 weeks. There isn't. So you can cross-examine on that statement if it is there, because I don't know the statement. Because that statement, it's actually the evidence of the witness, which is encapsulated statement. Then we are talking about a statement as if it is denuded of evidential material. It's not. Right, let's hear. You can proceed, you can cross-examine.
Just a clarification. I'm not saying the state shouldn't do that. In other words, now the ruling of the court is that the state can proceed
Yeah.
to cross-examine Mr. Gwabini on the content of the statement
Yes.
that the state says it wants to
Yeah.
use, despite the fact that there's an opposition which is grounded on the fact that the state must prove the statement
Yeah,
first.
no problem. That's what it is. You know, you've got your rights. You can take me on appeal. You can do whatever you want. But the ruling is
Yes.
a judge can change his ruling. Now, I'm saying I misdirected myself
Yes.
in having thought that it is about the statement. It is
Yes.
not about the statement.
Yes, ma'am.
It is about the evidence
Yes, my lord.
encapsulated
Yes.
in the statement.
Yes, ma'am.
Okay.
So my clarification, my lord, is
Yeah.
that the court simply is overruling my objection that before the state embarks
Yes.
on the statement that it wants to introduce and cross-examine Mr.
Yeah.
Gwabini on, the court says no, that should not happen. It can go directly and cross-examine Mr. Gwabini on the content of the statement
Yes.
without even,
As you say, proving the statement.
yes, my lord.
Fine.
That's the ruling of the court.
That's the ruling, yeah.
Thank you, my lord.
Okay. Yes, sir.
Udaba ke besinalo lana ngaphambi kokuthi nje singaqala ukuthi ke kunyaka ophelile uma ke sigcina ke la enkantolo kwanesikhathi la khona ufakazi ededelwa khona ke ngoba ke inkantolo yasiba nesinqumo esenzayo ethi ke nanjengoba ke ufakazi kuneyinsolo ezanazo ke ukuthi ke kunamaphoyisa bashiwo obrigadier Gininda oconstable Maphumulo oconstable Buthelezi osergeant Mukhane osergeant Mukhula ukuthi ke ufakazi ethi ke bamshaya ke ukuthi ke wabe esethi yena ke egcineni lokho nikushoyo ke ukuthi ke kune statement engasenza noma ke esenziwa uyena ke umsola wokuqala umnumzana uSibiya thathani lokho ke bese ningidlulisela ke nithi ke i statement sami mina ngizothatha nje ngokuthi ke ngisayindeke kuyashiwo ke ukuthi inkantolo lapho yase isho ke ukuthi ke labo fakazi labo abezeke bazobethula ubufakazi babo ke ngoba ke kuneyinsolo eyibhekiswe ngakubona manje ke abashushisi nabameli ke sebenza ke izethulo ke enkantolo ke mayelana nako ke lokho inkantolo ithi ke gcineni ke lana ke kuloko ebikushilo ke ngaphambilini yona inkantolo ukuthi ke lo daba lolu alukho mayelana nestatement ngoba ke kodwa kumayelana nento eshiwo uyena ufakazi umnumzana uZungu lana ukuthi ke esho yena ke ethi washo yena noma watshela amaphoyisa ukuthi lokho enithi kwashiwo uyena ke bese nisidlulisela ngapha mina ngizothatha ke ngokuthi ke ngisayindeke ithi inkantolo lapho ke kulokho ke ubufakazi lobo obuphuma kuyena ufakazi ila manje ke akhulunywa ngestatement kodwa akhulunywa ngento eyakhulunywa kuyena ufakazi isiyavumela ke inkantolo ukuthi ke usungaqhubeka ke umbuso ubuzeke ngaso leso statement leso bekhulunywa ngaso ke ungaqhubeka ubuze yena ufakazi imibuzo nokuthi ke bashilo nabameli ukuthi ke okwamanje ke angeke ubufakazi bakhe umnumzana uZungu bumisweke noma buhoxisweke ukuthi kubizwe lapho ufakazi nalapho iyavuma ke inkantolo ukuthi cha ngaqhutshekwa ngobufakazi bakhe buqedwe ke emuva kwalokho kuzaba la khona ke inkantolo ibisiyasho ke manje ukuthi kuzokwenziwa kanjani ngalabo bufakazi ngamafushane ke inkantolo yamvumela kumshushisi ukuthi angaqhubeka abuze ngaso istatement lesiyana ke ebemisela ukuthi ngaphambilini abuze ngaso.
Yes, sir.
As a court, please, my lord, I've just received an indication that the defense requests an adjournment for 15 minutes.
Why?
I think they can elaborate.
No,
It's actually me, my lord. I forgot my spectacles. I thought I would utilize the opportunity to go
I've got
first.
2 pairs spare.
No, I can't wear you.
2 pairs spare. One is for playing soccer, the other one is for...
Or even 5 minutes, my lord. I think I'll be back. My office is just
No.
behind the courts building.
You don't need to hear with eyes, please.
No, but I need to write, my lord. I'm writing.
No, you can
as
write.
well.
You can write.
So I don't
Ben
want to
said-
write in a skew way, my
No,
lord.
no, please. We've wasted so much time in this case.
It's
No,
just 5
continue.
minutes, my lord.
Instead of 15 minutes, we'll make it 20 minutes for your break, okay?
Thank you, my lord.
All right. You go. Yes, sir. Instead of adjourning for 15 minutes, we'll adjourn for 30 minutes so that you can fetch his spectacles.
No, I said 5, my lord.
You want 5 minutes?
Yes, I'll be back in 5 minutes
You're
because
going
my office.
out for 5 minutes?
Yes.
No, let's continue. Doesn't change anything. Okay.
I'm prejudiced, my lord. I'll not be able to take notes then in that instance. It's fine. We can proceed.
Yeah, fine. Okay. Yeah.
So when we last adjourned, we
So apparently there's something that Mr. Ngobe wants to bring my attention to. Might quickly consult with
Yeah,
you.
fine.
Thank you. Thank you for the indulgence, my lord. Simply, Mr. Ngobe is saying he feels a little bit uncomfortable that the court orders me to proceed without me having my spectacles on.
Yeah, is he an
Because-
ophthalmologist?
Eh,
Is he an ophthalmologist?
I mean, if his
But he's the one who's making a medical decision for you.
no, my lord, if his legal representative says, I'll not be able to take notes because I've forgotten my spectacle, then I would be in a position to go and fetch within 5 minutes, and then I would be back, and the court says,
You know what you'll do?
Proceed.
When we adjourn, we shall play the record for you to take notes which you're supposed to take. Is that okay? Let's continue.
No, it won't, that won't.
No, that's the ruling I make.
Okay, thank you.
Because you won't be able to take notes when we are all here. We adjourn. I'll instruct the stenographer to play to the fullest maximum blast the proceedings, and then you can take them, okay?
But my lord, that will simply make a mockery of this whole situation.
No, it doesn't.
It will. Thank
Because
you,
this
my
court
lord,
can't
but
be told by...
I respect the court's ruling. Thank you, my lord.
Ay, Jesus.
As the court, please, my lord. Perhaps to save time, as we still need a speaker to listen to the evidence, which is almost, 11:09, close to the time for the short adjournment. I wonder whether we should take that short adjournment.
Until what, 11:30?
Yes, for Advocate Nisi to collect.
He says 5 minutes. I'll make it 15 minutes. So we come back at 11:30.
I'm sorry.